Rights of arrested persons. So, rights of arrested persons will be asked as a short note and is a very important question in first unit. So, what are the rights of an arrested person? The first right of an arrested person is right to be informed of grounds of arrest. So, according to section 50, 55, and 75 of CRPC, the accused has the right to be informed of grounds of his arrest. The next right is right to be informed of rights of bail. So, according to section 50, clause 2 of CRPC, the arrested person has a right to be informed of his right of bail by police officer. The next right is right to be produced before magistrate without delay. So, according to section 56 and 76 of CRPC, the arrested person has a right to be produced before magistrate without any delay. The next right is right to be not detained for more than 24 hours without judicial scrutiny. So, according to section 57 and 76 of CRPC, the arrested person has to be produced before a magistrate within 24 hours after his arrest. And if the police officer fails to do so, then he will have to release the accused or the arrested person. The next right is right to consult a legal practitioner. The next right is right to free legal aid for indigent persons. So, if the arrested person is financially incapable of having a lawyer for himself, then he has a right to free legal aid. The next right is right to be examined by a medical practitioner. The next short note in this unit is First Information Report or FIR. The FIR can be asked for short notes as well as a long answer for 10 marks. So, section 154 of CRPC tells us the procedure to be followed while recording a FIR or First Information Report. The first step is the information to be reduced by writing by police officer. So, whatever information the informant gives, if he gives it orally, then it has to be reduced to writing by police officer. The next step is the report should be signed by the informant, and after that the report should be read over to informant by police officer. The next step is report be written in a book prescribed by state government. The police officer has to record the FIR in a book which is prescribed by state government. And for the offences under sections 354, 376 and 509, the report be recorded by a women officer. And the report should be recorded at a place of choice of the informant. The information should be videographed and the report be recorded by judicial magistrate. And the next step is the copy of report should be provided to the informant. And the next step is if the police officer refuses to take FIR, then a letter should be written to superintendent of the police, and the superintendent of the police will order that particular police officer in charge to take the FIR.